After 8 years of Bush secrecy and an estimated 20-plus court claims of state secrets privilege with which to hide facts from the American people tonight, the new Attorney General says he has been reviewing those claims and after looking at a couple expects to reverse one of them. Is that just one or one already? Our fourth story tonight, a follow-up to last night's report on Obama's defense and expansion of the Bush doctrine of presidential supremacy over courts and the people when it comes to issues of or allegedly of national security. The current issue, the case of Jewel v. the National Security Agency, former President Bush, former Attorney General Gonzalez, other officers of the Bush administration, for the illegal wiretapping, as discussed on this NewsHour by whistleblower Mark Klein, of Americans for the government by AT&T using secret facilities at its Folsom Street, San Francisco location and others. As we said last night, the Obama administration, taking its first crack at the case Friday night, not only defended the Bush claim of state secrets, seeking to dismiss the case entirely, but added a stunning claim that no one can ever sue the U.S. government over secret wiretaps, even if the wiretaps are illegal. The Attorney General, Mr. Holder, telling CBS News tonight he is, quote, likely to reverse one unspecified Bush claim of state secrets, but that in the other three claims they have reviewed so far, Mr. Bush was correct. With us tonight, one of the lawyers on this case, Kevin Bankston, senior staff attorney for the Electronic Frontier Foundation, which filed the suit. Thank you for your time tonight, sir.
Thank you for having me.
Your reaction to Mr. Holder's assertion that Mr. Bush's claim of state secrets was correct in this wiretapping case?
Well, we at the Electronic Frontier Foundation were gravely disappointed and more than a little outraged by the position that the Obama administration is taking. The Obama campaign promised us change we could believe in a new era of transparency and accountability from government. But instead, this is looking like deja vu all over again. And the Obama administration is embracing the same aggressive secrecy arguments that the Bush administration did, and is going them one better by arguing this incredible immunity argument, by saying that despite the many laws that we have that are meant to restrict the government from wiretapping us or accessing our communications records without warrants, that the government, the U.S. government, is immune from any lawsuit for violating those statutes and essentially eviscerating the privacy rights of millions of ordinary Americans.
Aren't they actually going to better? Because your lawsuit came about in large measure because members of Congress gave AT&T immunity, which nullified the lawsuit you had against AT&T, but also arguing it was more appropriate to sue the government, even using that to justify the passage of telecom immunity. Is there a legal term for bait and switch, and were you a victim of it?
We certainly were, although I don't want to say that they succeeded in nullifying our case against AT&T. We are currently litigating over whether the immunity statute they passed is constitutional. But certainly when the White House and the Justice Department were on the Hill pushing for that immunity, they said, hey, why worry? Even if they get immunity, you can always still sue the government. Now their tune has changed completely, and they're saying, wait, actually we meant to say no one can or should ever be held accountable for the NSA's warrantless spying, which is simply a shocking reversal and indefensible in our opinion.
How much hope is there that the worry about this is excessive, that this is not the huge policy assertion that it would seem at first, second, and third blush? I mean, don't Justice Department attorneys of every generation have to come up with whatever arguments they can when the government gets sued? Don't the courts have the final say in this?
Well, the decision to invoke the state secrets privilege was a decision of the administration. It did not have to do that. As you mentioned, Eric Holder is planning on withdrawing state secrets privilege assertions in another case. They could have done what we've advocated they do for several years and what the courts required them to do already in another case, which is submit their secret evidence through security procedures that are already laid down in federal law. As for the immunity argument, well, certainly lawyers are required to make whatever credible, colorable arguments they can to defend their clients. But this argument is simply incredible, literally. No one has ever suggested that the Patriot Act section they're pointing to does what they claim it does. Not the White House, not the Justice Department, and certainly not members of Congress. This is completely out of left field and is plainly wrong, as we look forward to explaining to the court.
Kevin Bankston, who will do just that as senior staff attorney for the Electronic Frontier Foundation in this pivotal lawsuit. Great thanks for your time and good luck with the case, sir.
Thank you.